everyone. Thank you for joining us today for Constangy's webinar, Immigration Compliance for Employers in an Era of Heightened Enforcement. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave some time to answer your questions. This program is approved for SHRM and HRCI credits. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm pleased to introduce today's presenters, Justin Coffey, Barbara Kihumba, Daniel Ball, and Kelly McGrath. Each is a member of our immigration team, with Justin serving as co-chair of the practice group. Justin, Daniel, and Kelly are based in the firm's Raleigh office, and Barbara is joining us from the firm's Atlanta office. With that, I'll hand it over to our presenters to get us started.
Great. Next slide. Oh, thank you. Hi, I'm Kelly McGrath, and first I'm going to talk about the H-1B visa, one of the most common work visas. The H-1B visa is available for foreign nationals employed in specialty occupations, requiring a bachelor's degree or higher in a specific field or its equivalent. So what are specialty occupations? They are roles that require the theoretical and practical application of a body of highly specialized knowledge and the attainment of a bachelor's degree or equivalent or higher in a directly related specific specialty. What roles qualify for an H-1B visa? There are a few qualifications, and you must meet at least one. Either the role requires a bachelor's degree or the equivalent or higher in a directly related specialty. Parallel positions among competitors also require a bachelor's degree equivalent or higher, or the role duties are so complex that they normally require a bachelor's degree equivalent or higher. Also, the foreign national must qualify for the H-1B visa by holding a bachelor's degree equivalent or higher, or holding an unrestricted state license, registration, or certification to fully practice the specialty occupation. Next slide. Okay, thanks. So H-1B compliance with the H-1B modernization rule. The Department of Homeland Security rolled out the H-1B modernization rule in December 2024. Changes to the specialty occupation include the degree must be directly related via the job having a logical connection between the degree and the position duties. Normally does not mean always regarding degree requirements. And the range of degree may be accepted for a role, but all of the degrees must be related to the sponsored position. The modernization rule also defined bona fide employment offers. The H-1B petitioner must establish that the proposed employment exists at the time of filing and as of the start date of the requested validity period. Does not require specific day-to-day assignments. It does codify that the work must be non-speculative. It does allow USCIS to review contracts to verify the bona fide employment offer. And as with the past, there's higher scrutiny for third-party placement sites. The modernization rule also touched on amended petitions. Petitioners are required to file an amended petition before material changes occur. Material changes include any change in work location requiring a new LCA and any substantive changes in the job duties. A change that would require a new LCA would be a move out of the metropolitan statistical area for which the original H-1B was filed, and substantive changes to the job duties. Examples would be changing from an individual contributor role to a managerial position, having a more than one level promotion, or a change in job family. As a reminder, H-1Bs are role and location specific, so you should discuss any changes with your immigration counsel prior to making those changes to make sure an amendment is not required, or if it's required that it's filed before the change happens. If there's a change in location within the same metropolitan statistical area, then we do something that's called an LCA reposting, which is reposting the notice of filing. If you do physical postings, that would be in the physical location. If the employee works from home, it's in their home. If you do electronic postings, it's on your intranet. Now, if you do not file an amendment when an amendment should be filed, USCIS can revoke the employee's H-1B status. It can create back wage liability, and it can lead to demotions if the company cannot pay the prevailing wage after taking care of any back wages. The H-1B modernization rule also touched on deference and maintenance of status. So while they codified allowing USCIS deference, which instructs officers to refer to previous USCIS adjudications that involve the same parties and facts where there's no material errors in prior determinations and there's no new material information to change eligibility, they're still requiring that you show maintenance of status documentation, and that should be included in all H-1B extensions and amendments. Maintenance of status documentations, things like pay stubs, prior approval notices, things like that. Right. Next slide. With the H-1B modernization rule, they also codified their existing authority to conduct site visits. In the past, USCIS has conducted inspections and compliance reviews, including on-site visits to ensure compliance with immigration regulations. That's now codified. They can conduct site visits at the petitioner's headquarters, the beneficiary work locations, satellite office, and third-party work sites. The new rule also implements consequences for refusing to cooperate with worksite visits, including denying or revoking any H-1Bs tied to that location. So all H-1Bs associated with that location. And under the current administration, site visits may increase. So a note on labor condition applications, LCA, under the H-1B modernization rule. USCIS will not question whether the Department of Labor has properly certified an LCA, but USCIS does have the authority to review the information on the LCA and determine whether it's consistent with the information in the petition. And then it's just a quick reminder on public access files. They're an important part of H-1B compliance. They should be maintained for the length of the H-1B validity period plus 1 year. The public access file contains the prevailing wage documentation, a signed and certified LCA, confirmation that that was sent to the foreign national employee, the notice of filing. If it's a physical posting, it should be signed and dated. If it's an electronic posting, it should have timestamps of the start and end date. The PAF should also include a actual wage memorandum and the summary of benefits. So on prevailing wages, the Department of Labor has a database of prevailing wages that's accessible to everyone. The prevailing wage is based on the position and the position requirements, and it's not based on the foreign national and their qualifications. So you can't select a lower prevailing wage level or a different prevailing wage just because the salary doesn't meet the prevailing wage. You must either raise the salary to meet the prevailing wage, or you can seek an alternative prevailing wage, which is outside of the Department of Labor database. The consequence for not paying the prevailing wage is that it violates the H-1B program and it creates liability for back wages plus interest. The H-1B modernization rule also touched on H-1B cap. It relies on a final rule from February 2024 that created a beneficiary-centric selection process where selections are based on a unique beneficiary identifier and not by registration. as a way to prevent beneficiaries from gaming the system. It also extended cap gap, which used to end on October 1st and now will end on April 1st. And cap gap applies to F1 students with valid OPT or STEM OPT work authorization and a pending H-1B change of status petition. The H-1B change of status cap petition must be filed before the expiration of the OPT or STEM OPT work authorization, and then it bridges their F1 work authorization until April 1st. So that's good news. Just a quick run through of H-1B cap lottery. There are 65,000 new H-1Bs available each year, with an additional 20,000 for foreign nationals that hold a U.S. master's degree or higher. And next slide, the selection process is that all of the registrations are run through the bachelor's cap first, and then registrations with advanced degrees go through the master's cap. So more H-1B cap are awarded to those with advanced degrees. And that doesn't mean, though, that just because you have an advanced degree, you're selected in the advanced cap. You can have an advanced degree and be selected in the bachelor's cap, which should be noted on the H-1B cap petition. Just noting that only about 30% are selected each year. The first date of H-1B status is October 1st. And just some quick reminders at the end of H-1B compliance here. If an H-1B employee is terminated before the end of the H-1B status, the employer must offer return transportation to the home country. They should also withdraw the H-1B and LCA to avoid having to pay back wages. Also, you cannot bench H-1B employees. We're going to skip forward just 2 slides. And as a reminder, H-1Bs are limited to 6 years, with exceptions for if you get to a certain part of the green card process with PERM and I-140. So with that, I will turn it over to my colleague, Dan Ball, to talk about the PERM process.
Thank you, Kelly. Good afternoon, everyone. As Kelly mentioned, I'm going to talk about the PERM process and any issues you should be on the lookout for. Just as an initial slide here, it's just a quick rundown of the PERM-based green card process. It's a 3-step process. You have the PERM labor market test is the first step, the I-140 petition for non-immigrant worker, and then the I-485 adjustment of status, which is the actual green card application. Now, the PERM is a labor market test to determine if there's any minimally qualified U.S. workers for the sponsored role. That's someone who meets the education, experience, and special or technical skills, as we like to call them. If those are met, then a qualified worker is found and the process must halt. On the next slide, I have the PERM process itself. It's also 3 steps. It's the prevailing wage determination, recruitment, and then PERM certification. Some things to note, the employer is responsible for conducting good faith recruitment and is responsible for the recruitment costs. So job advertisements that go out as part of the recruitment campaign, those are the responsibility of the employer. And the employee cannot be involved in the recruitment process, even though oftentimes they want to be, they cannot be. As Kelly was mentioning with H-1B time, we're seeing PERMs unfortunately take around 2 years to complete. It doesn't seem like that timeline is decreasing anytime soon. So it's just important to know when someone's on H-1B, for instance, when their max stay is, so you have enough time to complete the PERM process so they can receive that post 6-year extension. And on the next slide, I have just the preference categories for PERM. So those are EB2 or EB3. The important thing to note from this slide is simply it's the job requirements that determine whether or not the PERM is EB2 versus EB3. It's a common question we get. I'm sure you all get this question as well from foreign nationals requesting a certain preference category. it is the job description and the job requirements that choose it, not us. And then on the next slide, we have the actual job requirements. So just as a reminder, PERM is an employer-driven process. So it is the responsibility of the employer, usually the manager, to develop the job description and develop the minimum requirements for the role. Again, those are the education, experience, and special skills minimum requirements. It's important to know that they cannot be tailored to meet the beneficiary's background and experience. These should be the actual minimum requirements that you would require if you were filling the position today for a non-PERM role, for instance. You can have a PERM for a future position, but the job needs to be a bona fide job offer for the future. So you have to have the intention to actually hire the employee into this future role in the future. A couple things on salary and wages. The salary, the prevailing wage does not need to be met until the green card is actually approved. So it doesn't have to be met at the time of PERM filing, just by the time that the green card process is finished. For Indian and Chinese foreign nationals, this can be 10+ years before the prevailing wage actually needs to be met. Another thing here is state wage transparency laws. We're seeing those recently come into play, and you should just be aware that they may impact how you post recruitment and job advertisements based on where you're actually recruiting from. Employees should also be able to validate their minimum requirements. They must validate their minimum requirements, and usually this is through employment verification letters and their degrees and transcripts. We as a practice request that information at the beginning of the PERM process, so we don't get to the end and find out that they don't, meet the requirements for the position. And then on the next slide, I have some more information here on requirements. If the job requirements are not considered normal for the occupation, there is a business necessity justification needed. So this would be when the Department of Labor considers maybe the requirements as being more restrictive than is normal for that occupation. Then you would want to, as an employer, provide business necessity justification for why those requirements are needed. And another thing to know, just be aware of work locations, work modes, whether they're remote, hybrid, on-site, travel requirements. These are things that should be represented accurately at the beginning of the PERM in the prevailing wage stage, and can actually dictate how recruitment is done. So you may need to recruit out of company headquarters rather than where the employee is geographically located if the position is completely remote. And speaking of recruitment, there's, just as a reminder, there's 3 forms of mandatory recruitment. You have your 30-day job order with the state workforce agency, 2 Sunday print advertisements, and a notice of filing that gets posted at the worksite. If it's a professional occupation, then you also need 3 additional forms of recruitment. A couple points on the advertisements. You must apprise U.S. workers the job opportunity and geographical location of the position. And probably most importantly from this slide is be aware of application methods that differ for non-PERM positions. So an example of this would be if you don't want to have a requirement for a PERM position for applicants to apply and supply their resumes via mail, and then for a non-PERM position, allow a candidate to apply electronically, then having the 2 different processes could be problematic. And this one's pretty straightforward. You can't have less favorable terms for a U.S. worker as you would a foreign national, pay, benefits, moving expenses, those sort of things. And then on the next slide, I have some more information on the actual applicant review and disqualifying candidates that apply. So when a candidate applies, the employer must review each applicant against those minimum requirements. Again, the education, experience, and special skills for the positions. You are not looking for the best candidate only if they meet that threshold of minimally qualified. If one of those candidates are found, then the PERM process should stop. But if you receive a resume and you're doing your initial review of a candidate that applies, if they're clearly lacking education, experience, and skills from the resume, they can be disqualified. But if it's a closer call, we as a practice recommend that, always recommend to our clients to contact the applicant and confirm that they actually are missing a requirement. If a candidate does appear to be potentially minimally qualified, the employer has a duty to contact and confirm if they meet the minimum requirements. Usually this is in the form of an interview. And we always recommend to review applicants on a rolling basis rather than waiting to the end of the recruitment period to start reviewing, as this shows a good faith recruitment effort is going on. As you're going through recruitment, you should always be building an audit file. This is by regulation, you need to have an audit file that's retained for 5 years. It can be retained electronically. And that includes things like prevailing wage, notice of filing, and then the actual recruitment results. If there was interviews, documentation of that, all of the applicants' resumes, job postings on the state workforce agency, those sort of things should be retained in the audit file. And then we're moving to just sort of some red flags. We are seeing the current administration has been on record saying that one of their goals as an administration is to protect U.S. workers. So we do feel that will probably translate into the PERM environment. And so I've just flagged some things here that sometimes catch the eye of the Department of Labor. And one of the big ones is layoffs. So if there's a layoff in the same or related occupation in the area of intended employment within 6 months of filing a labor certification, you cannot file unless those laid off were notified and considered for the position. If it's then determined that they're not minimally qualified for the role, then they can be disqualified and you can file the PERM. But it's important to note here that even if you go through that process and there is no minimally qualified U.S. workers for the job, you still would need to notate that there was a layoff. And so sometimes it's beneficial for employers to wait beyond that 6 months before filing the PERM if possible. But it's just important to know that the layoffs can be an audit trigger for the Department of Labor. Sometimes foreign language requirements can draw scrutiny. They want to make sure that the role actually does require foreign language skills to be able to perform the duties. It's also important to know any job changes, promotions, changes in work mode, location, job title, and job requirements could potentially require a new PERM. And then lastly, if an employee is no longer employed with a company, it may be beneficial to withdraw the PERM to avoid the obligation to respond to an audit if there happened to be an audit that occurred after the employee is no longer with the company. And here I just put together a few best practices. The PERM process is sort of a strict liability process. If there's errors within the PERM filing, it can result in a denial. And sometimes those don't need to be major errors, they can be minor errors and they can still result in a denial. So we always have a strong quality control process before we file. Reporting procedures are important to know when to initiate those PERMs, especially as PERM processing times get longer. And, things like record retention processes, and importantly, if there's any layoffs, job changes and promotions, or entity changes, mergers, that sort of thing is important to know as well, as they can impact the PERM. But that is all I had. If Justin and Barbara want to take over.
Thank you, Daniel, and welcome everybody. My name is Barbara Kihumba. In this section, I'm going to be discussing I-9 compliance matters. We're going to be reviewing the timing of the I-9 document requirements for I-9 and hot topics that we've seen arise more recently, in particular with regard to TPS and termination of TPS and humanitarian parole. Just as a background on the Form I-9, the Form I-9 was created after the Immigration Reform and Control Act of 1986, which essentially placed immigration enforcement in the arms of the employers by requiring that employers verify the employment eligibility of all new hires hired after November 6, 1986, by completing the Form I-9 for every new hire after that date. The Immigration Reform and Control Act also made it illegal for employers to hire unauthorized workers, and employers who knowingly hire or continue to employ individuals who are not authorized to work in the United States can face severe civil and criminal penalties under the Act. Knowingly, basically knowledge may be actual knowledge or that the individual is not authorized to work in the United States, and also may be constructive knowledge. Important thing to remember, timing of I-9s. Section 1 of the I-9 must always be completed at the time of hire. And the statutory definition of time of hire is the first date of work for pay. Okay, the earliest, it can also be completed earlier than that, and the earliest it can be completed is after the new hire has accepted the offer of employment. Section 2 of the Form I-9 must be completed by the employer representative within 3 business days from the first day of work for pay. So for example, if the employee begins employment on Monday, Section 2 must be completed by Thursday, which would be the 3rd day. For individuals in the United States on temporary forms of employment authorization and temporary work visas who require reauthorization must always occur at the end of the employment authorization period. Late re-verification is considered a substantive violation under the I-9 rules. So with regard with regard to the document requirements for the I-9 and the onboarding process, a good practice in the onboarding process is to present the list of acceptable documents to the prospective hire, either at the time the hire signs the job offer, accept the job offer, or at the time of preparing the I-9. Always allow the prospective hire to determine the documents that they want to present for completion of the I-9 process. Never ask for particular documents or suggest particular documents to the new hire. In terms of the documents must reasonably appear to be genuine and relate to the employee presenting them. If the document appears genuinely and relates to the employee, the employer representative must accept the documents, okay? We're not required to be forensic experts and to scrutinize the documentation presented. But however, certainly if the document does not reasonably appear to relate to the individual, then the company representative does not need to accept the documentation. Okay, all documents must generally be unexpired. There are certain exceptions for individuals who are eligible for automatic extension of employment authorization, such as individuals on certain employment authorization documents, also individuals in the green card process who are utilizing green card-based employment authorization document, and certain workers on temporary work visas such as the H-1B, L-1, and the TN who are eligible for 240-day automatic extension. When the employee presents documentation, always make sure that you physically inspect the document. That's a requirement, that the document be physically inspected, unless the company is utilizing an alternative virtual procedure for I-9 verification. A good practice is that the company representative who's completing section 2 of the form should also be the individual who's physically inspecting the documentation presented by the prospective hire to complete the I-9 process. So several versions of the Form I-9 have been issued since the passage of the Immigration Reform and Control Act in 1986. Not every version can be used. So a good practice is always to make sure that you're utilizing the correct version of the Form I-9. Failure to utilize the correct version of the Form I-9 is actually considered a technical violation. So it's very important to always make sure that you know the current version of the Form I-9 and that you're ensuring that you're utilizing the current version of the Form I-9. Earlier this month, on April 2nd, USCIS updated the Form I-9 and a new version was issued by USCIS, which went into effect on the same day, April 2nd, 2025. The new version was revised on January 20th, 2025. Prior editions of the Form I-9 remain current up to the dates of expiration as stated. If the company utilizes an electronic version of the Form I-9, you need to make sure that the electronic version has the updated expiration date. A couple of updates on the new Form I-9 section. So USCIS updated section 1 of the form to rename, especially box number 4, where it previously said non-citizen authorized to work. USCIS renamed that, as alien. So just basically substituted non-citizen with alien to make it more compliant with the statutory language. And then another revision was the list B of documents, revised the term gender to replace it with sex. And also there's some revisions to the privacy notices and the statutory language on the form. Common mistakes to look at during the process of completing the Form I-9. These are some of the more frequent mistakes that we see when we audit Form I-9s. Not completing the Form I-9 within 3 business days, failure to re-verify employees who have temporary forms of employment, so failing to re-verify those employees timely, missing dates and signatures on the Form I-9, again, using the incorrect version of the Form I-9 and missing information on the form, and also neglecting to record the documentation presented by the employee correctly on the form. Couple of best practices, certainly one of the more recommended best practices is to have a standard written I-9 compliance policy. That's always very important. And also to designate an officer in charge of I-9 compliance in the company, ensuring that anybody, the individuals who are responsible for the I-9 process are well trained in the process of completing I-9s. Regular audits, regular I-9 audits are highly recommended. This allows the company an opportunity to basically, ensure that all hires in the company have an I-9 in the record, and also to fix any I-9s before any potential immigration customs enforcement audit. Also consult with counsel before making any immigration-related hiring and firing decisions. That's always recommended, especially in this time of heightened immigration enforcement. We've been fielding a lot of questions on I-9s. One of the most frequent questions we do get from individuals is basically how do you input individuals who have automatic extensions on their employment documents on the I-9. Certain individuals are eligible for an automatic extension of 540 days based on timely filed application to extend employment authorization. So it's very important, first of all, to a lot of the categories eligible for automatic employment authorization, such as individuals in the green card process, some TPS registrants, also asylees, for example, is that they must submit a Form I-765 application, a timely I-765 application to renew employment authorization. Okay, so the date on the receipt notice for the Form I-765 must be the date before the expiration date on the employment authorization document in order for the individual to be eligible for the automatic extension. There are certain exceptions to that. Another thing is that the category on the employment authorization document has to match the category on the renewal application. Okay, if the categories are a mismatch, then the individual is not eligible for the automatic extension. There are certain exceptions for individuals on TPS simply because TPS has two interchangeable codes. TPS is usually annotated as A12 or C19. So you can find instances where an individual has, for example, an EAD that was approved under C19 code, but then has applied for an extension and the new code is A12. That is absolutely acceptable. Another aspect to look at is individuals who are mostly non-immigrants on temporary work visas such as H-1B visa holders, L-1TN, and the like. These individuals are typically eligible for an automatic 240-day extension of employment authorization based on the timely filing of an extension application. It's very important to annotate on the Form I-9 the 240-day extension and to enter the date the extension was filed with USCIS in the additional field in Section 2. Do keep in mind that once the H-1B extension or the L-1 or TN extension is approved, that you're going to have to re-verify the foreign national under Supplement B of the Form I-9. Been fielding quite a number of, as you can imagine, given the news and the current affairs, we've been fielding a lot of questions on TPS Venezuela, as well as, termination of humanitarian parole for Cubans, Haitians, Nicaraguans, and Venezuelans. And just to keep in mind that this session is not going to cover broadly TPS requirements and the like. Just a very general overview as the situation is continuously evolving, continues to evolve as the litigations are ongoing. So what is true today may not be true tomorrow. However, in terms of right now, TPS Venezuela right now survives. As TPS Venezuela had two designations, one in 2021 and 2023. Prior to leaving office in January 2025, the Biden administration extended the second designation through October of 2026. However, after the elections, the Department of Homeland Security terminated the second designation for Venezuela, which affected approximately 350,000 individuals. On March 31st, the Northern District Court of California enjoined the termination of TPS and also the vacature of the 18-month extension for the 2021 and 2023 TPS designations. Next slide, please. So as of now, TPS Venezuela is still alive and well. And the 18-month extension is also alive and well for the 2021 and 2023 designations. employers, workers who were granted TPS under both designations with expiration dates as listed are eligible to extend their TPS and employment authorization through April 2nd, 2026. They're also eligible for an automatic 540-day extension of employment authorization. However, the automatic extension is limited up to the end of the second designation by the Biden administration through October 2nd, 2026. When verifying the Form I-9, it just, the category for TPS Venezuela is A12 or C19, and you make sure you just enter the April 2nd, 2026 as the new expiration date for automatically extended employment authorization documents. Another area that we've been receiving a lot of questions is the termination of humanitarian parole for Cuba, Haiti, Nicaragua, and Venezuela. So the humanitarian parole program for these countries was essentially established in 2022 and then extended in 2023 to cover, Haiti, Nicaragua, and Venezuela. On March of this year, the Department of Homeland Security moved to terminate the humanitarian parole for the CHNV countries, and effective April 24th, 2025, and all employment authorization under, that was granted under the C11 category was also terminate as of April 24th, 2025. However, on April 14th, the U.S. District Court in Massachusetts temporarily blocked the Department of Homeland Security from terminating the parole programs. So for now, parole program for Cuba, Haitian, Nicaraguans, and Venezuelan continues, and any employment authorization under the parole programs remains valid through the expiration dates. All CHNV revocation notices are stayed pending the ongoing litigation. You just have to, any individual who's authorized for employment under the parole program must present a valid and current employment authorization to continue employment. And with that, I will pass it on to my colleague Justin to discuss E-Verify.
Well, thanks for that detailed information, Barbara. As you all are probably already aware, I-9 compliance can be rather challenging. Another challenge that employers have to face associated with the I-9 process is the anti-discrimination provisions of the Immigration and Nationality Act. So back when Congress created the I-9 verification process in 1986, there was a concern that the I-9 verification process may cause employers to become too aggressive with respect to the I-9 verification process, which could then result in discrimination against individuals who are actually authorized to work. So Congress created the anti-discrimination provisions of the INA. And the anti-discrimination provisions specifically prohibit discrimination on the basis of citizenship status or national origin. It is illegal to discriminate in hiring, firing, or recruitment based on citizenship status or national origin or the perception of national origin. Victoria, could you flip to the next slide? It is also illegal to engage in unfair documentary practices relating to verifying employment. So employers are not allowed to demand more or different documents than are necessary and cannot request specific documents or reject documents that they should accept. Some of the common issues we see related to unfair documentary practices can include requiring specific documents. So for example, we may have a situation where we have a very well-intentioned and very efficient HR person. Perhaps they work at a facility that does a large amount of hiring, and they have scheduled days where they do onboarding for large groups of employees, and they want that process to go smoothly and efficiently. They want everyone to get through their new hire paperwork on day one not have to send people home, not have to delay start dates. So they may tell new hires, they may inquire, what's your status? Oh, you're a green card holder. Well, on your first day of work, you must bring in your green card, right? And they have just violated the law by doing that. Okay. So that is something to be aware of. With respect to requiring specific documents, if the government sees that we have a very high percentage, or say all of our green card holders presented green cards for I-9 verification, that may cause them to be suspicious as to whether the employer is engaged in unfair documented practice, right? Because green card holders can present other types of documents, like a driver's license and unrestricted social security card. They may not always show their green card for I-9 verification. The other issue that we see fairly often is over documentation, right? So someone may present, for example, an EAD card, a temporary work permit, and the person doing the onboarding process may think, oh, well, along with that work permit, I also have to see their social security card, for example, which is prohibited. They don't have to provide that additional unnecessary document. And some employees just want to give us all the documents that they have, right? They're not sure what to present. So here's my passport, here's my EAD card, here's my Costco card, here's my library card, here's everything I can think of. And some employers will just accept all those documents, copy them, and retain them. And then we have evidence on file that could potentially support an allegation that we're engaged in over documentation in the I-9 process. So if an employee presents just too many documents, we don't want to just accept them. We want to review the list of the acceptable documents with them and have them pick what to present and not just accept everything. It is also illegal to retaliate or intimidate employees for exercising their rights under the anti-discrimination provisions of the INA. Another area where sometimes we see employers get into trouble is mixing the I-9 process with other types of processes. For example, a company may have concerns about export control compliance, right? They may have export control concerns. And they may say, well, hey, we have someone going through the I-9 process. We can just use that process to also verify compliance for the export control rules, or maybe as part of our background check, or maybe we have a badging process for facilities, and we're going to use the I-9 process for other things. And employers should definitely not engage in doing that. If we use the I-9 process, first of all, is only supposed to be used for verifying the identity, employment authorization of employees. It's not meant to be used for other purposes. And if we use it for other purposes, we may wind up requiring specific documents or more documents or different documents. We may wind up violating the anti-discrimination provisions of the INA because we're using the process for something it's not intended for. So it is important to keep these processes completely distinct, right? Even though it may not be the most efficient onboarding process, that is the legally compliant process. And as a reminder, it's impermissible to re-verify U.S. citizens and green card holders, right? So a U.S. citizen, for example, let's say they present a passport, the passport has a future expiration date. Well, we don't need to re-verify that U.S. citizen when the passport expired. Their status as a U.S. citizen doesn't magically disappear just because their passport expires, right? The passport's just evidence of their status as a U.S. citizen. It's the same for green card holders, right? Green card status is permanent. green card has a future expiration date, but an individual doesn't lose their green card status, or permanent residence status, just because their green card expires. So we never re-verify green card holders. If we re-verify these individuals, that's an unfair documentary practice because it's requesting more documents than needed. So let's shift gears here, and we're just going to touch on E-Verify briefly. So E-Verify is a federal process which balances I-9 information against the DHS database and Social Security Administration's database. E-Verify is an optional process, except for when it's not. Certain federal contractors are required to be enrolled in E-Verify, and there are several states that have state laws that require certain employers to be enrolled in E-Verify. When we run the E-Verify check, we can get different case results. The typical case results that we most often see are employment authorized. So if we get that one, all good, right? Employee works, we close the case. We may get a final non-confirmation, which means their information didn't check out. And if that's the case, you should terminate that employee, and we can do so with safe harbor in terms of liability for the termination. Okay. The other case result that we commonly see is a tentative non-confirmation, and that is the one where we see employers sometimes struggle with that process. So let's talk a little bit more about the tentative non-confirmation process. So when a tentative non-confirmation is issued, that means that something did not verify with DHS or SSA. It does not mean that the employee is necessarily unauthorized to work. Okay, there can be lots of reasons that a TNC is issued. There can be mistakes in the paperwork resubmitted, which we want to check for. There can be mistakes in the Social Security database, in the DHS database, or when those databases may need to be updated, and it's not. So if a TNC is issued, we meet with our employee, okay, as soon as possible, but within 10 federal working days, we meet with our employee to advise them of the TNC. Then the employee needs to make a decision as to whether they're going to take action based on this notice or they're not going to take action. And they have 10 working days to make that decision. If the employee decides not to take action based on the TNC, then the tentative non-confirmation basically becomes a final non-confirmation, and the employer can terminate employment with safe harbor. If the employee elects to take action on that notice, then we go back into the system, we update the E-Verify system with that decision, and then the employee has 8 federal working days to visit SSA or DHS, whichever is appropriate. While the TNC process is being handled, we are not permitted to take any adverse employment action against the employee. Okay, we have to let the process play out. The employee continues to work. We continue to pay the employee. No adverse action while this is in process. When the TNC is in process, we go back and check the E-Verify system for updates. We may see an update that they are employment authorized. Great, we close the case, the employee works. We may see an update that the case is in continuance, which means we have to allow more time for the issue to be resolved. Some issues are resolved quickly, some take longer. We may see an update that says no show. That means they did not appear at SSA or DHS in the time frame allowed. And that essentially becomes a final non-confirmation, and we can terminate employment with safe harbor. Or we may get a final non-confirmation. And if we receive a final non-confirmation, again, at that point, we will terminate with safe harbor. So we're going to just touch briefly on ICE audits. This is something we're getting a lot of inquiries about right now. We could do a whole session on ICE audits, perhaps we will, but not today. So just the basics for ICE audits, right? First of all, an ICE audit's not a raid, right? It's not ICE agents swooping in, arresting people. This is a paperwork inspection. So ICE is going to serve the employer with a notice of inspection. And we have 3 days to produce the requested documents. 3 days is not a long time, especially if a lot of documentation is being requested. And in our experience, we can work with ICE to request an extension of that 3 days. And as long as our request is reasonable and we can justify why we need more time, they typically have agreed to provide those extensions. The notice of inspection will request all of our I-9s for active employees and terminated employees whose I-9s were required to keep within a required retention period. And they are also going to include an attachment to the notice of inspection that requests business documentation. Okay, these are going to be things like payroll records and other business documentation. And the reason they want this documentation is to ensure that we have an I-9 for every employee that we are supposed to. Here's being prepared for an ICE audit. Some of the basic things that all employers should be thinking about is having an immigration compliance policy on the I-9 process, identifying company contacts that can be contacted in the event we are served with a notice of inspection. We don't have much time to respond, and we don't want to lose time if people don't know, oh, what do I do with, who do I contact? What do I do with this? And we lose a few days just figuring out how to get this notice to the right person at the company. We also don't want employees at a facility engaging with ICE and providing information without our knowledge. We want to be in control of that as well. We do recommend employers consider using electronic I-9 software. The main advantage to that is it does help to prevent many common mistakes in the I-9 process. A good system will alert you if you're trying to enter information that doesn't make sense. If you're trying to enter a combination of documents that's not allowed, the system will stop you, and that will cause you to ask, what's going on? Something's not right, right? And take corrective action. And consider doing internal I-9 audits on a regular cadence to catch errors, correct errors. And that can also help identify if we have a trend of making common mistakes. And if so, we can then conduct training with our employees who do the I-9 process so that we stop making those common mistakes. Another best practice is to copy and retain the supporting documents for the I-9 process. The reason for that is if we don't retain the supporting documents, it really limits the effectiveness of our internal audits. It can be hard to both identify and correct errors on the forms if we don't have the documents to compare to. The last thing I'll say on the ICE audits is if you do have an ICE audit, you will receive, if there are errors, if there's technical errors, you'll receive a notice of those technical errors. And if you correct those errors, you should not be fined on those errors. If there's substantive errors, they may issue fines on the errors as well. And they may also issue a notice of suspect documents. If a notice of suspect documents is issued, that means they've identified employees that have presented problematic documents that may be fake or stolen. And in that case, typically those employees will need to be terminated. Here we have for you just some helpful government resources to go to on the I-9 process. because it is pretty complicated. With that, we'll turn it over to Victoria for our codes, and then we're pretty much at time, but we'll see if we have any questions here. So one question we have is about using the Spanish version of the form. It absolutely is acceptable to give the Spanish version of the form to employees. In addition to English, especially if they're, if English is not their first language. Another question is, should we re-verify upon name changes? And the answer is no. E-Verify is not used for re-verification. You can update the I-9 form for a name change, but we do not re-verify them in E-Verify. Now, if the name change is because someone has presented a new identity, that's a different question. I don't know if that's the nature of this question, but if someone has presented a new identity, in that case, the employer has the option of either terminating for violating the company's honesty policy, right? Because if they presented fraudulent documents, that would be an act we could terminate employment over. But we do have the option of continuing to employ that individual if they are now legal. In that situation, we would complete a new I-9 form. We would attach that I-9 form to the old one with an explanation, and then we would run them through E-Verify in that circumstance. I believe we are now over time, so we thank everyone for your time today. And if you have any follow-up questions, feel free to submit them.